Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start. The instant appeals have been preferred against the judgment and order dated 4th January 2010 setting aside the award passed by the Industrial Tribunal dated 14 November 2005 answering the reference in affirmative terms holding the termination of the appellant's workman to be void being in violation of section 25 of the Industrial Disputes Act 1947 herein after being referred to as the Act 1947 with a direction of treating the workman deemed to be in service till their services are validly terminated with 50% back wages stop. The brief facts called out and relevant for the purpose are that the first respondent university was established by an ordinance viz. University of Sanskrit Ordinance 1993 stop the appointments of non-teaching staff in different categories viz. Watchmen, attenders, peons, sweepers, assistant cooks, assistant drivers, helpers, waiters, gardeners, clerical assistants were made at different points of time on daily wage basis during the period 1993 to 1995 under the orders of the then Vice Chancellor. Their services came to be regularized by the first respondent, giving them the status of regular employees by an order dated 7th May 1996 stop. It appears that as some objections were raised questioning the manner in which the regularization had taken place, the first respondent by a later order dated 24 March 1997 deregularized the non-teaching staff employees and in consequence thereof their services came to be terminated stop. So far as the order of deregularization passed by the first respondent dated 24th March 1997 is concerned, it has attained finality after the division bench of the High Court has upheld the order of deregularization dated 24th March 1997, taking note of the initial engagement as daily wager and the appointment being without going through the process of selection as prescribed under the scheme of University Ordinance, recorded a finding that the order of deregularization passed by the authorities is valid and justified and left the question of non-observance of the provisions of the Act 1947 open to be examined in the appropriate proceedings known to law stop. It may be further noticed that the grievance of the teaching and non-teaching staff was jointly examined by the division bench of the High Court, while deciding the writ appeal under its common impugned judgment dated 23rd March 2000. Stop. Para 10 of the judgment of the Division Bench of the High Court dated 23rd March 2000 relevant for the purpose is reproduced as under. Other point raised related to non-observance of the requirements of the ID Act as rightly observed by learned single judge same is not to be decided in Article 226 applications since applicants, if they are so advised and feel that they have a right under the ID Act, can approach the forum. Stop.